Welcome to the Foley's Access to Capital Web Conference, How to Manage the Antitrust Risks Associated with Mergers and Affiliations. Today's conference is being recorded, and at this time, I would like to turn the conference over to Mr. Roger Strode. Please go ahead.
Good morning, good afternoon, depending on where you are, everybody. This is Roger Strode. I am a partner with Foley and Lardner in our national healthcare practice, and I'm resident in our Chicago office. I want to thank everybody and welcome you to a continuing installment of what's been our very successful Access to Capital webinar series. In today's series, we're going to discuss something that a number of people have asked us in past Access to Capital webinar presentations to discuss. And what we'd like to talk about today are the antitrust risks associated with mergers and affiliations of healthcare providers. And really what we're going to talk about today is managing those risks and give you sort of the nickel tour of what goes on in healthcare, what's causing a lot of these mergers and acquisitions, what the antitrust risks are, and how you can manage those risks. I am delighted that today I'm going to be joined by two of my colleagues, both of whom I work with quite closely in healthcare transactions. Alan Ruttenberg, who is the chair of our national antitrust practice and resident in our Washington, D.C. office. Alan is an expert in Hart-Scott-Rodino compliance as well as other aspects of antitrust and is a graduate of Harvard Law School. My other colleague joining us today is David Simon. David is a member of our government enforcement practice and has a tremendous amount of experience in healthcare M&A and especially the antitrust aspects of healthcare M&A. David is a graduate of the University of California at Berkeley, Bolt Hall School of Law. We also have a special guest speaker with us today, Lawrence Wu. Lawrence is the president of NERA Economic Consulting, and he's resident in NERA's San Francisco office. Dr. Wu's expertise is in the economics of antitrust and intellectual property. Dr. Wu has a lot of experience in testifying in U.S. district courts on a variety of regulatory proceedings. And prior to joining NERA, he was a staff economist with the Bureau of Economics of the FTC, and he's currently a visiting scholar with the Stanford Institute of Economic Policy and Research. Dr. Wu earned his PhD from the University of Chicago Graduate School of Business, and he has a BA from Stanford. We at Foley have been very lucky to work with NERA Consulting and specifically lucky to work with Dr. Wu. So I would like to thank all three of you gentlemen for doing this today. I think those of you on the line are going to really enjoy their comments and remarks, and you're going to find them, I hope, incredibly helpful. Before we start, it's my job too to do to give you a few housekeeping tips. So that you know, today's program is going to run for 1.5 hours and will apply for 1.5 general CLE credits. New York, New Jersey, Kansas attendees applying for CLE credit have to fill out the attorney affirmation form and write down the course code that I'm going to be giving sometime during today's web conference. It's a secret. I'm not going to tell you when I'm going to give it, but it's a secret and you will get it. And a form and today's slides can be obtained in the handout section of your screen. Feel free to submit questions during the course of the web conference by entering them in the Q&A box that you see on your screen as well. We'll do one of two things. Depending upon how the conversation goes along, we may intersperse those questions if I think that at the time they're relevant, or we may hold those questions to the end. So with that, I'd like to get us started today. And the way we're doing this, I'm the moderator. I will moderate this today, and I will be providing and really teeing up questions for each of David, Lawrence, and Alan. Lawrence, I'd like to start with you. Let's just kick this off. I know in my practice, and I know that many of the folks on the line here are probably interested in this, we are seeing a tremendous amount of merger, acquisition, and affiliation transactions. And in fact, I think it's probably fair to say more hospitals are exploring mergers than any time in recent history. Can you give us a little background on what you think and what you see as driving this trend?
Sure. Thank you, Roger. Well, the picture says it all. There has been a huge increase in hospital M&A activity since 2009. You see a big jump in 2010. And the expectation is that there are more transactions to come. And I think, we can attribute this to the passage of the Accountable Care Act, but really it's much more than that. There are just fundamental changes in the market environment in which hospitals compete, uh, and uh, and we can talk about more of the reasons in a little bit.
Um, each one of you, well, I think the audience is going to be interested in each one of you providing us with kind of your perspective on the types of affiliations and forms of affiliations that we're seeing. And Lawrence, if you could kick it off, and then David, I think everybody would be interested in what you and Alan are seeing. So that if Lawrence, if you could give us a few minutes on this, and then David, and then Alan.
Sure. So in terms of transactions in the healthcare activity in general, we can think about the kinds of consolidation that we're seeing. I think there are a couple of big things I would point to. One is that there's a lot of vertical integration. Hospitals are doing more than hospitals. They're thinking about they're acquiring physician groups, for example. Now, this is an old 1990s strategy, but it's back. And this all goes back to hospitals finding ways to deliver healthcare more efficiently and effectively. And you also see hospitals interested in doing more in the insurance segment. I think there's this thinking that hospitals need to be, that they can reduce costs and provide better quality care if they are also offering insurance. If you think about in California, Kaiser is a fully integrated healthcare provider, and hospitals are trying to move it into that direction. And as you know, later this year or in October, with the healthcare exchanges, a lot of hospitals are also seeing opportunities by offering their own insurance product.
And this is David. I agree. In addition to the straight hospital merger activity, which is, as Lawrence noted before, is sort of skyrocketing. I think it's the emergence of these systems of healthcare that involve both the vertical kinds of acquisitions of physician and physician groups, and expanding into insurance and risk management. And I think a lot of this is just driven by the change, the change in the way I think everybody expects healthcare to be paid for in the future. We're moving towards global payment type systems where someone needs to take responsibility for managing the care that's delivered to patients in the most efficient way. Sometimes that involves accepting, the risk of the cost of providing that care. But I think all this consolidation that we're seeing is really at sort of a core level driven by a desire to put together a system that can care for a group of patients and to manage that whole process efficiently and effectively. At least that's what I tell the Department of Justice and the FTC when they ask.
Alan, what other kinds of forms of affiliations are you seeing?
Well, I'm principally seeing the same types of things that both David and Lawrence referred to, a lot more different types of vertical arrangements, particularly physician group acquisitions by hospitals and straight-out horizontal acquisitions, and it's also reflected in what we're seeing from the agencies. And if you look at some of the recent enforcement trends we're going to mention in these slides and cover later, you see that there's the traditional challenge to the more quintessential hospital combination with another hospital horizontal transaction, but you've also seen, recent examples of enforcement actions where hospitals have acquired physician groups. I think the other thing we're seeing, though, is hospitals also exploring other types of arrangements and affiliations that are sometimes, many of the things we're seeing are, fairly tight integrations of mergers or forming new systems or taking over, control, but we're also seeing companies exploring a variety of other options, including looser forms of affiliation, like a joint operating agreement, where parties may preserve some substantial elements of independence, but combine for certain aspects, which in and of itself raises, somewhat different antitrust issues than the traditional straight-out acquisition?
It is interesting, gentlemen, that you say that, because in my own practice, I'm seeing all of the above. And what I think we as transactional lawyers wrestle with, because we do see all of these various creative arrangements, or we're asked by clients, what other things can we do? We're maybe not ready to completely merge, but we know that we want to go to the market together, and do things. For example, they will say to us, gosh, we really want to get together with XYZ in the market, and we want to put together a managed care product that we can go to payers and employers with. Or we want to make decisions around, we know that they do cancer better than we do, but we do hearts better than they do. What sorts of things can we put together? And we as transactional lawyers, we sort of sometimes become flummoxed by the antitrust issues. So if you can, Alan, could you talk a little bit about really the issues that have arisen? What are the kind of critical issues that you're seeing that arise from these various forms of affiliations? And then when you look at this as an antitrust lawyer, do you feel better when you see a tight merger versus a looser affiliation? And what are the kind of the issues that you start talking to clients about when you see these looser affiliations as opposed to tighter mergers?
Right, and I think I think it depends somewhat on what is the product that the parties want to deliver and how they want to do it. If particularly if the goal of the parties are to do something like jointly contract and jointly price, that's a situation where typically you're going to be in a better position from an antitrust standpoint if there really is a tighter affiliation and control, like through a merger or acquisition, or you can establish that you've got sufficient and adequate clinical integration, because just getting together to do something loosely where parties preserve their independence and may have in many ways very divergent economic interest, you can come into situations where at the end of the day they may be subject to challenge under basic Section 1 of the Sherman Act, which governs conspiracies and contracts and combinations and restraint of trade, of acting as one where they really haven't, through common control or integration, been able to achieve that. And so I think it's but we've also seen other parties coming together to do other things, whether it be group purchasing or clinical affiliations, where they're combining to deliver care and improve the quality of delivery, but they're doing it in a way that doesn't implicate some of the more sensitive antitrust areas like pricing. And in those situations, there's typically less pressure and less of less critical nature that the parties really be tightly integrated and or commonly controlled. David, you want to add to that?
Yeah, no, I think that's right, and the obviously the focus of some of our legal analysis today is going to be on the merger context, and some of these affiliations, the looser joint operating agreement, virtual merger type approaches, sort of kind of come down to the same sort of analysis at the end of the day. Some of the more creative combinations or cooperative arrangements have to be looked at more under a Section 1 conspiracy type analysis. Is there an agreement that unreasonably restrains trade? And as you move into common pricing, which is often a part of these decisions, the antitrust risks obviously go up.
I know as healthcare transaction counsel, and we spend a lot of time advising clients on, whether it be a joint operating company or whether it be a complete merger. Clients can get confused between sort of the horizontal aspects that two otherwise competitors can't do versus just the pure, what I would call kind of the hardcore antitrust aspects of whether or not the combination, assuming that you combine correctly and can take horizontal activity and can engage in horizontal activity, whether or not that in and of itself will also substantially affect competition. Alan and Lawrence, can you talk to us a little bit about what regulators right now are looking for and how regulators assess whether or not a merger or an affiliation or whatever it might be is going to have impacts on competition itself. And I would say things like impacts on market share, HHI type of impacts, where they're looking at these transactions and they're saying this could substantially affect competition.
Sure. And even though we are in a new environment, a new healthcare environment in terms of really a lot of regulatory change, a lot of change among how payers are pushing providers to deliver care, the basic elements of the antitrust framework of how the agencies review mergers and acquisitions remain the same. I mean, it is important to be able to articulate to the agencies why you're doing the deal, and I think increasingly what we're seeing in the deals that are being brought to us is that, parties really are doing transactions with an eye of trying to improve quality, trying to take out cost, trying to be more efficient and improve the delivery of care, and prepared to deliver care in a different model than they've done in the past, all of which are positive. But the important thing to know when you're thinking about the acquisition is, even though those are good rationales to explain to the agencies, in approaching the agencies, they're not just going, if it's a deal that's going to substantially reduce the number of competitors or substantially increase market share in a market, they're not just going to blindly accept arguments that, we need to do this in the face of a changing healthcare environment. Any defenses, any arguments on synergies, efficiencies, improvements in quality, they really need to be concrete, very specific to the extent you can, and tied in as much as possible to how this is affecting the local market, not just sort of national or broader trends. The basic framework that's applied to mergers and acquisitions is Section 7 of the Clayton Act, which very simply says, transactions are prohibited where the effect of the acquisition may be substantially to lessen competition or to tend to create a monopoly. In practice, how the agencies apply this, and at least in terms of hospital deals, at least at the federal level, most but not all of those are done at the FTC. The agencies typically apply an analytical framework that's modeled off of joint guidelines between the FTC and the DOJ that look at things like, what is the relevant market, what is the share, what is the concentration, what's the increase in concentration, what are the competitive effects, are there efficiencies? And even though very, very hard to establish, every once in a while there's the merger guidelines also recognize a failing company defense. I'll just spend a second covering some of the elements that often turn out to be highly key in the merger investigation context, particularly when we're talking about hospital deals. One is, what is the relevant product that's being assessed? So what is the impact on a particular product? In many hospital deals, historically, the focus has been heavily on general acute inpatient services. One trend we're seeing is that the FTC in particular has increasingly been alleging markets that are more narrow. So you see in the ProMedica case they've brought that's currently on appeal to the Sixth Circuit, they've alleged a specific line of service in and of itself as a relevant market. Another recent example, which we're going to cover later in the presentation, is the fairly recent Reading Health System deal, where they alleged a variety of product market definitions that were much more narrow than just general acute care. I mean, one was inpatient orthopedic spine surgical services. The other one was outpatient orthopedic spine services. So, and there were a couple other, but again, not just even inpatient, but inpatient versus outpatient. So what that means when you're assessing your deal, especially early on, that it's not just sufficient to kind of look around and say, we're going to be okay on antitrust because we've done the nose count and there's enough hospitals, there's enough competitors. Increasingly, the agencies are looking on a service line by service line basis. So when you are considering the risk and who to pair up with and what the process is going to be and what the risk is going to be, that needs to be assessed too. Another key area of hospital merger enforcement is, what is the geographic market? And often this is heavily contested between the agencies and the parties, where oftentimes the parties are saying you need to consider these competitors, they're a little farther afield, and one of the agencies making a pitch for a more narrow definition. I mean, generally you consider where the health plans and payers can turn to or would can turn to for services. There's different ways in which you can define the market. So, for example, in one recent enforcement action, the government defined the geographic market as being the target hospital's primary service area as they defined it in their ordinary course business as the set of zip codes from which that hospital drew approximately 85% of its patients. In another recent enforcement action, the agency defined or alleged the market to be a particular county. I mean, really what's going to come down to the relevant geographic market is going to be somewhat the facts and circumstances of the particular deal. Very important are going to be things like how do the parties consider the market in their own internal documents? What are going to be the perspectives of consumers, of third-party payers? So if third-party payers are interviewed by the FTC as a part of investigation and they say, we could not build a network for employers in this city without one of these two hospitals that are combining, and it wouldn't be sufficient just to substitute someone in from the town away, that's going to be very influential on how the agency considers the geographic market. The other thing that we're increasingly seeing as an important argument in the merger context is efficiencies, because parties really are trying to drive transaction to improve quality and cut costs and improve delivery of care. But again, to get traction with the agencies, and in some instances, to the extent that you can establish and prove that the merger-specific efficiencies outweigh the competitive effects, the agencies, will still clear a transaction that may otherwise have negative effects, but it's a fairly substantial burden to be able to prove that efficiencies truly are merger-specific. So if you make an if you allege that you need this to improve cost, the questions are going to be, could you do it another way? To the extent you can prove that there are, you've really thought it through, and in the deal analysis documents done to consider deal, there really was a lot of detail on how it's going to be done. Or if one of the parties to the transaction has done a series of acquisitions similar to the one that's in front of the agencies, can they point to what's happened in past deals to show that these assertions of efficiencies really have come true and are more likely to come true here? With that, I'll turn it over to Lawrence to give a little bit more of a direction from how he looks at it from an economics perspective.
Sure, thanks, Alan. From an economic perspective, I would emphasize three things. The first one, Alan, you mentioned is it's important to have a clear explanation for the rationale for the transaction. And this goes back to a question, Roger, you raised at the very beginning, is why are we seeing all of this M&A activity? And there are three things I would point to. One is the increased need to obtain greater economies of scale and scope. What are we seeing? Hospitals are anticipating a reduction in Medicare and Medicaid reimbursement. Insurers are being tougher in negotiations with hospitals. And if you're going to see revenue reductions, hospitals have to do one thing to deal with that, and that is they need to reduce their costs and be as cost effective as they possibly can. And a transaction that leads to economies of scale and scope helps you get there. The other, and this is especially important for standalone hospitals, and that's why if you look at a number of these transactions, many of them are transactions involving acquisitions of a standalone hospital. So I think for hospitals that are essentially independent, they are being acquired is probably number one on their list of strategic goals. The other thing about where the market is going is, what are the trends in healthcare delivery? If you talk to hospital executives, many of them who are very far-sighted realize that what we know about hospitals today is not going to be what hospitals will be doing tomorrow. Hospitals are going to be more accountable for healthcare costs in a population, and that means that it's not just about providing hospital services to patients in the hospital. It's more about what's going to happen if patients are not going to be in the hospital, and that's that shift from volume reimbursement to value-based reimbursement. And that's why hospitals care a lot about being more cost effective. So number one is the rationale for the transaction. The second thing I would point out I would highlight is it's even more complicated today to assess the competitive overlap between merging hospitals. And this, of course, is central to analyzing the competitive effects. Now, I've got a couple, two scenarios for you. The most basic one is the acquisition of a standalone hospital, and that's whether it's a system acquiring a standalone hospital or two standalone hospitals coming together. The analysis is going to focus on where the hospitals get their patients, and is there much of an overlap in the service areas of the hospitals. What I'm also seeing more recently is you have hospital systems wanting to acquire a standalone hospital, or hospital systems joining with other hospital systems. And by hospital system, you might think about some of these major metropolitan areas where you have a system with 3 or 4 hospitals and they want to merge with a system with another 4 or 5 hospitals. How you assess the overlap between the hospitals is much more complicated there. And what I would point out is there is system-level competition in that area. So it may be, is it the number 2 and number 3 system in the metropolitan area that's combining? There's going to be analysis at that level. And there's also going to be analysis at the very local level in a suburb or in a portion of the city. Or let's look at the overlap in downtown. And that's a focus on that it requires empirical analysis. The third thing I'm going to say is that the Federal Trade Commission in particular are very keen on trying to predict the effect of a proposed acquisition. They're applying economic models, doing empirical analysis to try to get that, get the answer to these questions. Very difficult given all the big changes in the healthcare market, but it is something that they are focused on more than before.
Lawrence, I would add one.
Please go ahead.
Oh, Lawrence, I'd add one more supplemental point, which is, I think tied into what you said and my point on that, it's not just a head count of how many hospitals are in an area because, the increasing trend to look at individual service lines in some instances, but also, the agencies consider, are the hospitals that are combining, are they particularly close substitutes? Are they each other's closest substitutes? And how you can determine that can be, different ways. Are these two hospitals that payers may view as both critical, having at least one in a network? Are these two hospitals ones who, from their internal documents and from the perspective of consumers and payers, ones who are constantly making improvements and taking steps to better compete, directly against the other? So again, when we're assessing early on what is the risk, it's helpful to early on take a little bit deeper dive and not just say, how many hospitals are in the area and how many discharges they have, because increasingly the analysis is looking even more deeply at, some of the things in terms of, how closely each competes with the other and in what service line.
Right, Alan, that is a great point. And it also goes back to the framework that the FTC is applying these days. They're looking at how a transaction changes a hospital's bargaining power. If they think a transaction will increase that hospital's bargaining power so that they get higher reimbursement rates, that's a key issue that the agencies are focusing on. So you're right, it's much more than counting hospitals.
Lawrence, a question that's arisen in my mind, and one that I would like you to address, if you can, just very briefly before we get into, and this will really lead into some of the enforcement trends that I want David Simon to speak to. But if you look at some of the fairly smart financial thinkers in healthcare and most of the large investment banks, a lot of the predictions are that the survivors through the Affordable Care Act and the survivors over the next 5 to 6 years will be hospital systems that have at least $2 billion in revenues. And for those of us who work with hospitals realize that generally requires a system that likely has 2,000 to 3,000 beds within the system to have over $2 billion in revenues. How is it that the agencies are going to wrestle with that? There have been predictions that the consolidation in the healthcare market and the healthcare industry is going to look very much like consolidation in banking, where you're going to get the sort of the too big to fail kind of arrangements. How are the agencies going to wrestle with that?
That is a great question, and I have a couple of observations. One is the agencies are are very sensitive to the idea that there are benefits from transactions, just like what you said, and the potential that there are economies of scale that will require in the future hospitals to be much bigger than they are today. So the agencies recognize that. This is where they run into the issue. They're trying to balance that potential for that benefit against what they see as the immediate short-term reduction in competition among hospitals the way we know it today. The future, they recognize that the future could be very different. And so their challenge is how they make that trade-off. And in some cases, if you can show them what the future is, and that is very helpful. But that's fundamentally the problem, because the agencies tend to have a shorter term horizon. So it's important in presenting to the Federal Trade Commission and the Justice Department what the longer term vision is.
Yeah, let me just follow on that. I think it's a really good point, and it's a struggle, because in my experience, the agencies don't give enough weight to the future. They are very focused on the present and on the immediate effect, and it's a real challenge persuading the lawyers and the economists that they should think about the way things are going to be in a year or 2 or 3 years down the road. My experience has been that they're still very much focused on that kind of, standalone hospital, independent doctor, atomistic sort of approach to healthcare. I think most people in the industry recognize it's going a very different direction from that. But it's an uphill climb to persuade the agencies of it.
Yeah, that's right, David. The other thing that the agencies consider is whether there is a potential to correct any potential anti-competitive effect later if that were to happen. And so some of the agencies, for example, might think about letting a transaction through, letting it play out, and then doing a retrospective analysis of the transaction. And if they are convinced that they actually have a potential remedy in the future, that would make them more willing to let a transaction go through today. So I think if the structure of the transaction is such that they see a remedy in the future, I think that's another good argument to make.
Well, that is, I think, a really good lead into the next question I have, which is, David, seeing what we've seen with Rockford and OSF in Rockford, Illinois, ProMedica in St. Luke's and Toledo, Phoebe Putney down in Albany, Georgia, the Reading, Pennsylvania situation, the amount of antitrust scrutiny and corrective action that appears to be going on seems to be unprecedentedly high. Are we imagining that? Is that correct? And can you spend some time talking about what's been going on out there?
Yeah, absolutely. And I think that the short answer is it has been extremely high. FTC in particular, which as Lawrence mentioned earlier is kind of typically the lead agency on hospital deals, has been aggressive and has expressed its intent to continue to be aggressive in the antitrust front. That's fueled in part by, I think, a response to what's happening out in the marketplace, which is as we've discussed more aggressive merger activity, but also some success that they hadn't experienced for quite some time in challenging hospital deals. So they've had some success, and I think that's breeding some confidence and maybe a little bit more aggressive of an attitude on the part of the FTC. Let me just run through, because I think it's helpful as we think about the best way to get your deal through antitrust scrutiny, to get a sense of where these challenges have come from and kind of what the basic facts of them are. And then I think, Lawrence and Alan and I will comment on what we see emerging from this. And there have been a bunch of challenges in the last couple of years, and let me just run through them real quickly. The first, as Roger mentioned, Phoebe Putney in Georgia. This was a merger to a monopoly. I think from an antitrust perspective, it was sort of a no-brainer in terms of the Section 7 analysis. The interesting twist on Phoebe Putney was that the parties sort of structured the transaction to run through a hospital authority so that they could invoke the state action doctrine to avoid antitrust scrutiny. I think everybody recognized that if antitrust scrutiny were applied, that the merger would be in trouble. The district court found that it in fact did. The state action doctrine did apply. The 11th Circuit affirmed that decision, and then just this spring, the Supreme Court reversed. I think it was 9-0. Alan, correct me if I'm wrong, but sort of forcefully reversed and held no, in fact, a generic grant of the authority to acquire and sell hospitals was not a clearly expressed state policy that had foreseeable anti-competitive effects. So that enforcement action, I think, is more interesting for the state action holding than it is for the actual economics and antitrust analysis of the deal. The next couple are, I think, a little bit more telling. Roger mentioned Rockford, and this was a lot of you will remember there've been attempts to merge the three main hospitals in Rockford for quite some time. This was a second crack, a different combination of parties, but a second crack, and it was really a 3-2 merger. So you were taking three competitors in the area down to two. The FTC sued to challenge it, and the end result was an injunction was granted by the district court, and the parties promptly dropped their deal after that injunction was granted. And the FTC alleged in this case that the hospitals were must-haves for commercial payers. They said in their complaint that the health plans must offer at least 2 Rockford hospitals to be marketable to local residents. And so we're not persuaded by the parties' arguments that there's a third hospital that provided a check on any anti-competitive effect that might have resulted from the challenge. So this analysis, I think, was largely driven by the economics, and I think you'll find in a number of these cases they're heavily economic driven. This one, like some of the others, had the added problem for the parties of having some bad internal documents that suggested that in reality that the purpose of the merger was to increase leverage with commercial payers, which I think you probably all know or have figured out by now is a real problem for a merger, and that's sort of a common theme in this. I mean, I think you'll see sort of the two sort of main themes in terms of these challenges. One is the economics show a pretty significant anti-competitive effect and a pretty significant potential decrease in competition. But the other thing you'll see is that there's, I think, a real question of what the motives for the deal are. Are the parties really trying to do all the good things that we've been talking about, or is this really just a way to increase their leverage? And I think there were, in this case, in the Rockford case, there were indications that maybe they weren't so pure of heart.
David, one question on that. Was there also an added wrinkle in that both of those systems as well controlled a sizable number of employed primary care physicians in the market? And I know that wasn't the driving factor, but didn't the agencies also discuss that at some level?
I believe that's correct. The analysis was focused principally on the hospitals, but it's always interesting in these mergers because more and more, as a result of some of these vertical arrangements that Lawrence talked about that are trending up again, there's this separate market that for physicians, and particularly primary care physicians who drive a lot of referrals to hospitals, that I think more and more frequently is playing a role in the analysis. You have anything else? Okay, so let me jump to the Pennsylvania Reading Health System. This was a challenge, again, by the FTC of the acquisition by a pretty significant, I mean, I never use the word dominant provider, but a pretty close to dominant provider in the market of a physician-owned surgical hospital that was, fairly nearby. And Alan mentioned this before. I think one of the most interesting aspects of this challenge was the fact that they defined relevant markets pretty narrowly, and found high combined market shares, in the 50 to 70% range in some of these very specifically defined markets. One of the things that I think was also interesting about this challenge is there were a lot of documents that showed that the big player hospital in Reading viewed this physician-owned surgical hospital as its principal check on competition. They were clearly nervous about them. There were documents that showed that they viewed this as a defensive merger to prevent somebody else from coming in and taking that over and building a robust competitor to the dominant incumbent. And so again, the lack of a pure intent in terms of what they're trying to accomplish helped make this prompt this challenge. Again, this, like Rockford, as soon as it was actually a little bit. It was before the injunction proceedings were held. As soon as the FTC announced its challenge, the parties abandoned the deal. And then the next one, and everybody's mentioned this too, the ProMedica St. Luke's deal. This was a 4-to-3 merger in Toledo. Similar to Rockford in the sense it was an urban area, but fairly fairly isolated geographically, and a fairly high concentration of hospitals, high market shares as a result of the proposed merger. You can see from 47 to 58%. And again, the core allegation by the FTC here is that from the perspective of the commercial payers, the merger would make the combined party a must-have, and that would impact the bargaining power and ultimately impact prices for health care. And that is what drove the decision. I think one of the most noteworthy aspects of this challenge was, as Alan mentioned before, the definition of a separate product service market for OB. And that was the FTC's position. In OB, the post-merger combined share of the parties was over 80%, and they cited that and used that as a basis for challenging the merger. That's a particular issue on appeal. The case is now on appeal. The parties have litigated this aggressively and have taken it up to the Sixth Circuit. And one of the interesting questions we expect to see out of that decision is whether, in fact, the Sixth Circuit concludes OB as a separate market. Wanted to just make a note of a deal that wasn't challenged recently to sort of give you a sense of maybe the differences. 2012, Yale New Haven Hospital acquired Hospital of St. Raphael, also in New Haven, Connecticut. These hospitals were 6 blocks apart, and like some of these other geographies, the nearest competing hospital was quite a ways away. a couple of factors that I think influence the agency's analysis of it is one, Yale New Haven needed capacity. They were oversubscribed. St. Raphael was just the opposite. They were struggling. They had excess capacity. The parties presented to the agencies very concrete plans to consolidate services, and Yale New Haven was going to invest some significant dollars, $160 million, in the struggling hospital. But I think the most important thing here is that the economics, and again, the economics, and Lawrence can probably speak more to the nuances of this, but they showed that the parties weren't really a competitive check on one another, that people didn't go to St. Raphael as an alternative to Yale New Haven. And for insurance companies, for payers, it didn't present a viable alternative. You weren't going to substitute one for the other in some sort of insurance product. So you didn't, the St. Raphael didn't provide a competitive check on Yale New Haven, so therefore combining wasn't going to really impact the dynamics in the market. One last point on just the history of this, just to follow on what Lawrence said before. You all probably recall the retrospective merger to Evanston Northwestern, the Evanston Northwestern Hospital deal. And I think it's important to keep in mind that just because a deal gets through, either because you don't have to file an HSR or you do file and it gets approved, doesn't end the scrutiny. And the FTC in that Evanston Northwestern case came back based on evidence that prices increased faster than market rates, and again based on documents that showed an anti-competitive intent, and challenged it after the fact. So that's a risk that always remains out there.
David, with this, what do the three of you, I mean, these 4 or 5 cases seem to drive certain trends or themes. Are there any particular transactions that you guys are seeing right now, or types of transactions that are likely to generate a challenge? And then just give us some idea of arguments and defenses that are effective and those that probably are not.
That's a great question, Roger, but if it's all right, let me just step back a bit and say that there are many, many hospital transactions that are approved and actually do not result in a second request. And so, in fact, that is probably, in my experience, the majority of transactions that I've been involved in. Many more have been approved than challenged. And I think this is, if I had to step back, if you look through David's summary, you see the phrase must have quite a bit, which is, the theory is generally, are payers going to say that the combined firm is a must-have entity? And by that, what payers are saying is, well, if I'm going to sell an insurance product in a city, do I have to have that provider? If the payer says that, well, there's no alternative, I have to have that merged entity, then that's going to be a flag for a transaction that is likely to be approved. That's why the Yale New Haven is not so much of an issue, but potentially ProMedica and in Rockford. Now this is where I would say there is a little bit of there is some controversy at the agencies on this point, because the agencies recognize that there are efficiencies, yet something like price is much easier to measure than quality. And so if I had to think about flags for transactions that are more likely to be challenged, it would be transactions where payers can more credibly make the argument that the merged firm is a must-have provider system. And second, if they make the claim that pricing is very important, and pricing becomes the focus because it is measurable. And then where the quality arguments or the efficiency arguments are less measurable, that's something that that's something that makes it harder for the merging parties to show that there are benefits. And again, it's not to say that there aren't benefits, but but there is the issue that price is much easier to measure than quality.
And just to follow on the point about the must-haves and the insurance company, sort of maybe just a practical point on this. Those are important players in the whole process, the health plans. And we usually advise our clients to keep that constituency in mind as they're moving their deal forward. And it's often sensible to communicate early and often with your key commercial payers about what you're doing and why you're doing it and why it's a good thing. And that obviously requires having a good story that doesn't involve more leverage with commercial payers. But to really want to accomplish some things that are good for patients and good for consumers, it's worth at least considering whether you want to try to influence the debate by influencing the commercial payers on the front end.
That's a good lead-in to, David, to the next set of questions I'd like to ask. But before that, we do have a question that came in from the audience. I think I could even answer this, but I will let the three of you answer it. The first question, two questions actually. The first question is whether or not the Clayton Act applies to nursing homes, long-term care, or memory care facilities. And I would presume what they mean by that is mergers of those organizations.
Right. Let me. This is Alan Rettenberg. I can grab that. I mean, so there's the substantive Section 7 of the Clayton Act, which governs transactions which may substantially reduce competition or create a monopoly. And there's no subject matter exemption under the Clayton Act. I mean, under substantive antitrust laws, just as in other industries, there's no blanket exemption they potentially can apply. Where the question may be coming from is, and we'll cover later on the slides, there's an issue of whether a deal is required to be notified in advance to the FTC and DOJ under the Hart-Scott-Rodino process, which is really a procedural statute. And in that instances, certain types of acquisitions have rule-based exemptions or statutory-based exemptions, and certain don't. There are certain types of assisted living or independent and assisted living facility deals that have been allowed to be exempt if they meet certain rule criteria under an exemption for basically rental or residential real property. That HSR exemption has not been historically applied to skilled nursing facilities, nursing homes. Now, the HSR exemption that has been applied in a number of instances to assisted living facilities that are not nursing homes has also been applied in a number of instances where there's very similar services being acquired in an attached wing that supports Alzheimer patients or memory care, but it's not at the level of care of a skilled or nursing home.
Well, thanks, Alan. And actually, there was a follow-up question to that, and while this is fairly broad, I'm sure one of you can boil this down. As the other question was whether or not there are state laws and regulations to consider in mergers of those types of facilities as well as in hospital systems.
Yeah, I mean, I will say for all the types of acquisitions we've been discussing today, hospital as well, I mean, we've talked a lot about primarily the FTC, but in all these types of healthcare deals, typically the state AGs are very active, and a lot of the challenges, including some of the ones David covered, in bringing the complaints and bringing the cases to court, the state AG is a party with the federal government in bringing those. So, yes, I mean there are certainly state counterparts to antitrust, and we've seen in a variety of industries, even unrelated to healthcare, there are some times where the federal agencies don't pursue something on substantive grounds, but for whatever reasons the states do. I mean, typically the process is, typically if it doesn't rise to the level of an enforcement action under antitrust by the federal government, it's often the case that the states don't separately pursue it, but that's not always the case.
Right. I mean, it's usually the principal focus, just I think largely because it's rare for these antitrust enforcers in the state AG's office to really have the resources to mount this on their own. But it is it's a good question, and it's something to be paid attention to. I think some of every state has its own, legal framework, but some of the laws are even more flexible in general and give them, some real power if they're inclined to do so, to challenge.
Gentlemen, we have about a half an hour left, so I'm going to move the presentation along so that we get, and the audience gets some of the practical aspects. Dave, could you talk a little bit? You really alluded to this earlier when you started to discuss, discussions with payers, et cetera. When you're considering a deal, so let's say you're a deal lawyer, you're like me, and you're sitting down and you're counseling a client right now, and we consider an awful lot of stuff when we're talking about a deal, but clearly, in this environment, and depending on the market you're in, and depending on what you're doing, you got to really start thinking about antitrust issues early rather than late. So when you're in the process of considering a deal, when should you start thinking about the antitrust issues, and what are some of the practical things that you should be doing both internally and along with your counsel? And David, if you could kind of tee that up for us, and then Alan, I may want you to talk a little bit. You and I have talked before about deal-killing documents, and then Lawrence, if you could follow that on with the economic assessment and how early you want that, and what kind of steps you can take to assess the economic risk and when you should be doing it.
Okay, well, I'll start. So, as I said before, I think the purpose and the intent it becomes so critical in the analysis. So ultimately, as you're thinking about a transaction, if you don't have a good sort of pro-competitive motive or plan, the question of why are you doing this, and if there's not a good story for how it benefits consumers and patients and what good stuff you're going to do as a result of the deal, you're going to have more trouble from an antitrust perspective if it gets scrutinized. And Alan will talk about bad documents, but bad documents, arise because the intent is, not bad in a moral sense, but in an antitrust sense, it's not why you're doing the deal, and therefore people tend to write emails and say things that are unhelpful if that's really the purpose of the deal. So I would say most importantly is, to have in mind and to be driven by, pro-competitive reasons, and I think there are some compelling ones that we've touched on before. Just as this environment changes, there are lots of reasons why consolidation allows hospitals and healthcare systems to provide better care at a lower total cost, and have that in mind. One of the things we have included in the handouts is the brief filed by the American Hospital Association in the ProMedica Sixth Circuit appeal. And I think it's a really well done piece that sort of describes, in general terms and in sort of high level themes, why consolidation is important for hospitals in this environment. And it's probably worth a read if you're thinking about hospital deals to be familiar with some of those issues and to start thinking about how your proposed deal fits within that framework, because it lays out a pretty compelling pro-competitive framework, I think. Just some more kind of more mundane but practical points on this. It often makes sense to engage counsel, either engage your inside counsel or outside counsel fairly early in this process. It allows you to create to put the privileges in place as you're assessing and preparing for a potential challenge. It allows you to have appropriate protective oversight over your conversations with a potential competitor, because before we even get to the issues of whether the deal can be approved, you have a whole separate set of antitrust issues that surround your conversations with an actual or potential competitor about the deal and what information gets shared and what agreements are reached. So having counsel involved in that process at some level provides a level of protection that may end up being important. It also allows you, as you get more concrete in your thinking about it, and want to make an early assessment about what the antitrust risk is. Counsel can help you with that, but counsel can also engage someone like Lawrence to do some, preliminary economic analysis to get a feel for whether this seems like the type of deal that's going to get challenged, and you can do that under the privilege of counsel's directing it. So that's important. The other just sort of two last, kind of mundane practical things. You really want to make sure you're documenting your process appropriately. And, I know most people on this call probably have done this 100 times, but, you want to have in place some kind of non-disclosure agreement, making it clear, that you're sharing information with the other side only for the purpose of the deal, for assessing the deal, limiting the use of the information shared. That provides you with some protection from a collateral collusion type claim, and also protects your proprietary information. You also may want to think about a joint defense or common interest agreement with the potential merging party. That's typically a little bit farther down the line in the process, but again, that allows you to work together to maybe jointly retain an economist to do an assessment of the deal, to share information that allows you to do a more robust antitrust analysis early to assess the risk. So those are some of the practical things that I recommend as you start down this road. Alan, you want to go to the doc?
Yeah, sure. Let me jump in on the document piece. So I think it seems relatively a simple concept that it's important that parties not create bad documents, but particularly for companies that haven't gone through a lot of acquisitions. Let me give a little bit of framework of how this stuff comes out. I mean, first of all, for deals that are of the size that have to be reported in advance to the government under the Hart-Scott-Rodino Act, you've got to include with the actual filing a broad array of documents in response to what are called items 4C and 4D of the HSR form, which are, broadly speaking, all documents prepared by our foreign officer or director to evaluate or analyze the deal with regard to competition, competitors, market share, potential for sales growth in the product and geographic markets, or synergies and efficiencies. And these aren't just board presentations and board minutes and offering memorandums. These could be an officer's or director's handwritten notes. These can be just email chatter. These can be due diligence reports. So even if you've got a deal that's too small to be reportable, you need to remember that if a transaction gets investigated, if you get a CID, subpoena, second request, all sorts of documents are going to come out, and what that means is that as you draft documents, even though it's not the way in which you generally think about it from a day-to-day business perspective, you need to think about it from how it would be viewed from the context of a regulator or a judge or a juror looking at the document. And why it is so critical not to create documents that say things like, this deal will create leverage over payers, is that in a best case scenario, a bad document like that could make a deal that wouldn't get much review or scrutiny subject to a very prolonged scrutiny or investigation. On a deal on a margin, the bad documents, may make a difference on whether the deal gets challenged or not. And if you look at it from a regulator's perspective, when they're thinking about if we see problems and if we go to court and we try to challenge it, how do we frame that up? How do we sell it? How do we make our case? Well, we've talked about all sorts of things that are subject to economic analysis, and each party can put on experts that interpret the data differently. The government can put on witnesses to give the payer's view on how this deal will impact them. But if the government's got something that's, that they can frame up, they can blow up on a screen and on a projector and say, this is what the parties were thinking when they were considering the deal, and there's a big email that says, let's do this deal so we can get leverage over the payers, that's going to be awfully compelling evidence. The other thing I'd like to say from more of a practical standpoint is, yes, it is important to start thinking about document creation once you are considering a deal, for sure. And, counsel can give you and give your deal team a variety of guidelines on do's and don'ts for creation of documents. But it's also important, particularly if you're in an organization that does a lot of transactions, where you're frequently engaged in the transaction process, to put in place internally a process and guidelines before you're even doing a given deal to help train and educate people drafting documents on types of things to say or to avoid. Other recommended practices can be either in the normal course process or in the deal process is making certain types of documents subject to in-house counsel or outside counsel review. So for example, before you give the annual strategic or long-range plan to the board, have it reviewed by counsel while still in draft, because that's exactly the type of document that's for sure going to come out in an antitrust investigation. It's also important to keep in mind in the document creation standpoint the role of outside advisors. So, it's not just the companies that are generating documents, it's consultants, it's bankers, it's people putting together the offer memorandums. And, there's always a tension here where, the company, if you're trying to sell a hospital, for example, and you're trying to frame an opportunity, there's always a tension that in putting together the offering document from the business standpoint to try to capture the best value for the business, and try to present to people who may be unfamiliar with the asset, how do we frame this as really a special and unique asset? Well, unfortunately from an antitrust standpoint, the way in which that sometimes is done by saying, this is the dominant provider in the so-and-so county market. Well, from an antitrust standpoint, the market may be much broader. But that's the type of thing where, how you frame it in the deal documents can later come back and haunt you in the deal process. So particularly if you're doing a deal where you think there may be antitrust pushback, there may be antitrust scrutiny, there may be antitrust concerns, again, that's something where the banker can coordinate with counsel to get input, before that's put in final, before it's sent out, and to help manage the process early on. And Sure.
I just want to just emphasize that point because, consulting firms, in my experience, have created some of the worst documents I've seen. They're not sensitive to these issues. You don't have as much direct control over them, and you just got to rein them in. And especially if you're in something more specific and concrete in terms of a potential deal, you may want to try to figure out a way to just tell them not to come to your office with a PowerPoint presentation, because it will likely do harm.
David, that's a very good point. And the transactions that we're involved in, and especially most recently, when we have consultants working on integration analyses and kind of clean room type of arrangements, we ask as counsel that prior to those documents being released to the clients, that antitrust counsel or legal counsel on both sides have a chance to review the document, clean up anything that would give them concern before the document is released. And in fact, what we've started to do is before the consultant is engaged, we actually ask in the engagement letter between either the consultant and us or the client and the consultant that it be made clear that none of those documents are released until they're reviewed by legal counsel.
Right.
Lawrence,
Yeah,
can you talk a little bit about how NERA is brought into these deals, early, late, whether you're brought in the middle, and then the analysis that you're asked to do, is it often a full-blown analysis immediately of the entire transaction in the market, or do you sort of step your way through it?
Sure. There are three reasons that I have been brought in early on transactions, and let me just say what they are. Probably number one is how important is it to get the deal done and to have greater certainty that the deal gets done. So for example, I worked on behalf of Medco when Express Scripts acquired Medco last year. And Medco's key question, management's question, the board, and Medco's board's question is, can we even get this deal done? And that's very important for them to know because they realize there's going to be opposition politically, there is a high shares, and so they needed assurance that it was going to get done. So that's when we come in early to do an analysis of their data and to give our best assessment, again, working very closely with counsel. The second, and that comes into point number two, which is we also get in early when there are issues with when the antitrust risk and who assumes the antitrust risk is a key issue in the merger negotiation process itself. So, for example, you're thinking about AT&T's proposed acquisition of T-Mobile. There's a breakup fee there was a huge breakup fee if the merger did not go through. That is a part of the merger negotiation. So when counsel and business want and management want to know how should they trade off the price, purchase price, and contractual provisions on who assumes the antitrust risk and whether there should be a breakup fee, that's where we have come in to play early too, and again working very closely with counsel. And then the third thing, and this is something that's come up much more frequently in hospital mergers, and that has to do with working, for example, on behalf of a bidder. And all the M&A activity that we're seeing in hospital mergers is basically the same thing as when you have multiple buyers for a house. Okay, so you've got multiple buyers going after a particular hospital. And as you might suspect from the efficiencies of some of these transactions, the multiple bidders may both be hospital systems in the same geography. So then the question is, the bidders want to show to the target that, don't worry, it's all right if we acquire you because the antitrust risk is not as great as you might think. Okay, and that's where a bidder wants to convince a target that the antitrust risk is not as high. And so we've been involved in those kind of situations where, again, it's early on because it's pre-deal and you're trying to convince the seller that the risk is not as high as you might think.
Very good, very good. We've got a gentleman, and ladies and gentlemen in the audience, we've got about another 17 minutes or so. Those of you in New Jersey, New York, and Kansas, you have been very good listeners and very good boys and girls, and for that I'm going to reward you with your CLE code. So this CLE code, this is the code you're going to need in order to get your CLE credits. It's a four-letter code. It is QDAR. And let me repeat that. It's Q as in quotient, D as in dog, A as in apple, and R as in Ruttenberg. QDAR, so that's your code. Guys, in the last portion of this, I think what a lot of people are going to want to know about is, first they're going to want to know if a transaction has to be reported under Hart-Scott-Rodino. And Alan, I'd like you to talk about kind of, what is that process? How do you manage it? What are the fees? Who prepares what? Who does it? How do the agencies look at it? Who looks at it? And kind of what is their process? And then we can talk a little bit about second requests, how expensive is it to comply, et cetera. And then David and Lawrence, I'd like you to kind of round it out, if you could, to talk about how you manage costs and delays once you get into these deeper regulatory reviews, and especially when you start getting second requests, or you get multiple requests, or even if you're not even in a Hart-Scott-Rodino filing situation. And then talk a little bit about how attorneys and economists, what you can do to reduce the antitrust risk and convince them during the course of a review not to challenge a deal. So, Alan, if you could jump into the Hart-Scott-Rodino filing process, that would be most appreciated.
Sure. And just as a little bit of background, again, I think we mentioned earlier that there are substantive antitrust laws that can govern your transaction, whether it's reportable or not, and even small deals may be subject and get challenged, well after the fact of closing. But what the Hart-Scott-Rodino Act is, it's a procedural statute that tells you whether or not you have to notify the government in advance and observe a waiting period before you file. And that's an important thing to know early on because it may impact the deal timing. It may impact what you put in the purchase agreement in terms of allocation of risks and efforts, as opposed to a deal where it's just going to be a sign and close. It may impact how you allocate various risks and expenses. And not even though hospital deals are often fairly sizable, not all hospital deals are subject to HSR. There's a quote from the then chairman of the FTC from a speech given in 2012 that said, these are rough numbers, but according to public sources from 2000 to 2011 witnessed approximately 333 hospital mergers nationwide. About one-third of those, approximately 111, were reported to the FTC under the Hart-Scott-Rodino Act, which means there's a lot of deals that were either exempt as just too small, or there's also an exemption I'll mention in a minute. But if you have to file, one thing to keep in mind is the waiting period is 30 days unless it gets extended for a more prolonged investigation. Despite all we've said about hospital merger enforcement, which is a real and definite trend, there are a lot of deals that either because there's enough players out there, or if it's someone a system acquiring a standalone hospital in a different geography, there's also a lot of hospital deals that don't raise issues. And in fact, according to that same speech by the FTC chairman last year, only about 1/10 of those 111 hospital deals that were notified triggered a second request, which is a much more prolonged investigation. So how do you know if you're subject to HSR? I mean, one basic test is the size. It's indexed every year, so it's not a round number, but it's 70.9 million. A question I get all the time on deals where it's someone's coming in as a membership substitution taking over the board, or if it's two folks merging but there's no deal consideration going on. How do I value that? Well, there is a way to value it. The HSR rules provide a process whereby you've got to do a fair market valuation in accordance with the rules, and depending on the structure of the deal, the valuation can be tricky, but that's the basic size threshold. The other thing is, for deals of certain sizes, the parties have to be a certain size. So if the deal is worth less than roughly $300 million, at least one party has to be at least a $14.2 million person, and the other a $141.8 million person in terms of typically annual net sales or total assets. There are some variations. Typically in the hospital deals we see, the size of parties test is met. There's one important exemption I want to point out, because it comes up a lot in nonprofit deals we look at, which is there is an HSR exemption, although you have to look to make sure your particular facts fit it, where nonprofit formations, where there's a new nonprofit form that's going to be its own ultimate parent, and where this comes up often is two hospitals coming together to create a new system, or two systems coming together to create a new system. In those instances, depending on the facts, that can be exempt from HSR reportability. But again, highly fact specific, and it's something that we typically, before relying on it, put an informal opinion request into the FTC. In terms of who prepares it, typically, if you have an obligation to file, there's a filing on each side of the transaction. There's a filing fee. It depends on the value of the deal. It can be from $45,000 up to $280,000, depending on which band it falls into. Parties negotiate everything, including who pays it. The rules say it's the acquiring person's obligation, although in some instances parties negotiate splits or other variations. And there's often very close coordination among the parties, and it's typically a process that you'll want to start several weeks in advance of being ready to file. In terms of what to expect once you file, again, filing kicks off the initial waiting period on deals that do pose antitrust issues because of overlaps. It's not uncommon to get questions during the initial waiting period. Sometimes those questions are for things like, give us your major payer contracts, or give us your strategic business plans, give us, market share analysis, things like that. There are various stages at which counsel and economists working for the parties step in and make presentations and pitches to try to convince the agency why they don't need to investigate further. If your deal is one of those where you are unfortunate enough to get a second request, basically a second request is a broad list of interrogatories and document requests that require giving substantial data from substantial numbers of people within the company. It's typically a very expensive process. The average cost of compliance with a second request is in the millions by the time you consider lawyers, economists, electronic vendors, and others. And it's not just a question of, as you're thinking about your deal, and to Lawrence's point, considering which of your bidder choices raise more or less antitrust risk. Am I willing to go through the process with someone who may take longer from an antitrust review process? It's not just a financial expense which can be negotiated. It's also taxing on management in the company, because typically you need a lot of coordination between counsel and the economist and the parties' business people in order to successfully respond to a second request and address agency questions. And with that, I'll turn it over to David, to Lawrence, if they want to jump in more on sort of the process after the second request, or even more nuance on the second request process.
Yeah, I'll give maybe a less nuanced point, which is this all will take longer and cost more than you expect. It's a difficult, painful process, and generally the agencies are not all that sensitive to the fact that the world continues to march on and the competitive environment changes, and you're if you're in that situation, you're sort of in a limbo because you can't move forward with the deal out of concern of gun jumping, and you're kind of stuck, sort of waiting for them to finish their process while your competitors are doing, kind of moving on with life. And so it's a challenging and frustrating experience that you really just need to be prepared for and to factor in at the front end when you're considering what the deal looks like.
Sure. This is Lawrence. Here are, Roger, your question. Here are the things that I would suggest doing to reduce delay after second request and to move towards a resolution. And based on my experience, but number one is to start early, because if you do think that the transaction will result in a second request, we know that the FTC will ask for a lot of data. Collecting the data and giving the data to the FTC in a format that's usable can take time, and you don't want to waste time after the second request. You want to anticipate that, so getting folks who know what the FTC wants will speed up the process. The second thing is it's important for us, and with counsel, to do the analysis for the FTC. So if there's data from the merging parties that's helpful, it's better for the analysis, for us to do the analysis, as opposed to just giving the data to the FTC and have the FTC economists do it. The FTC economists, for example, are very good, but they are pressed for resources and they're pressed for time. And so it's much more efficient if you have the merging parties economists to do the work. And then you can present it and do the work for the FTC. And probably the third thing I'd say is, as part of that, that's the only way you ensure that the analysis is complete, because to really speed things up, you want an analysis that answers questions, not an analysis that raises more questions. So that would be my advice.
David, is there anything from a legal counsel standpoint that you can add to that, to what Lawrence has said about reducing either the risk here or convincing the agencies not to challenge a deal?
Yeah, I mean, I think I agree with Lawrence. I mean, I think being proactive is usually a better strategy, and shaping, to the extent you can shape their thinking about the deal, early, it can pay real dividends in the process. I think, credibility with the agencies is key, and if you can do what Lawrence suggested and present them with a fair, objective, but pro-deal analysis, that will help, and has at least the potential to move the process along more quickly, which also has the potential to reduce the cost.
Excellent. Gentlemen, we have about 5 minutes left. I'd like to maybe give the audience a chance. If anyone has any questions, please submit your questions. Otherwise, what I'd like to do while we're waiting for any of those questions to come in, I do have one last question that each of the three of you could spend a minute or two on. I think it's going to bring us to the end of our time here. If you can look out into the future over the next 2 to 3 years, what all do you think is going to happen, both in merger activity, affiliation activity, as well as enforcement activity around healthcare mergers and acquisitions? And Lawrence, if you could start, I'd appreciate that.
Sure. Well, I think the challenge is what is what is the way, what's the way the hospital marketplace is moving? It goes back to what the future of hospitals, what are hospitals going to look like in the future? And I think for us to be able to talk about the quality benefits to patients, and really put into antitrust terms what hospital management is really trying to accomplish, I think is really important.
I think in a lot of ways what we're talking about now is fighting the last war. I think the market is changing. I think hospitals are going to play a less critical part the healthcare delivery, process than they do right now. They're always going to be important and critical, but I think we're going to continue to see, increased emphasis on things like primary care and ambulatory surgery centers and things like that, outside the hospitals, which is often less expensive. So, it strikes me when we're having these discussions sometimes that we're really, it's going to seem a little silly in 5 years because the concerns that we're trying to rebut are going to be less real.
And Roger, I would say just from a, looking out from a 2 to 3 year perspective, I would say, I think the trend is going to continue of a large number of deals and a lot of antitrust agency scrutiny. I mean, one of the reasons to think about the antitrust agency scrutiny is in an increasingly consolidating environment, the order in which you do a deal sometimes matters. So if there's 6 providers in a geography, the first 2 to combine that brings it from a 6 to 5 may be an antitrust non-event. But as people start to increasingly pair up and look for partners in consolidation, not only it's not just the volume of the deal, it's that there's going to be, I think, increasing concentration occurring because of the deals, which again will drive continued regulatory scrutiny.
I think I'd echo all of your comments, at least from a transactional standpoint and a transactional lawyer standpoint, and seeing the volume that I see out there. There appears to be really no slowdown yet. I think in terms of the arc of this process, we're in the middle of the bell curve. I think it's going to be a while before we see a declining trend on acquisitions, especially when you look at some of the bigger deals that are happening, like the Community Health System HMA deal, and some of these larger deals, and then the fact that there are so many hospitals out there that are bereft of capital, are really wondering, how do I have the money to go out and recruit physicians because I really need physicians for my strategy. I think you're going to see, a lot more acquisitions of hospitals. I just think the trend will keep going. For everybody out there listening, I want to thank Dr. Wu. I want to thank David and Alan. If you want information on NERA and Dr. Wu, you can find it at www.nera.com. And if you'd like to find contact information and bios for David and Alan, you can go to Foley and Lardner's site at www.foley.com. I think that probably concludes at least the remarks of the professionals today. Z, is there anything that